The law has always asked a deceptively simple question. Who did it? That question anchors responsibility, justice, and also compensation. But when a decision is made by a self-learning system, the answer blurs. Like, for example, an autonomous drone strikes the wrong target. A self-driving car swerves, saving passengers but killing a pedestrian. A trading algorithm, it crashes a market in 3 seconds flat. Who in those moments did it? We built these systems to act without constant human instruction. They observe, they interpret, and they decide. And when they decide wrong, the law must decide who bears the blame. Traditional liability theory offers 3 suspects: the manufacturer for defective design, the operator for negligent supervision, and the user for misuse. But autonomy breaks this triangle. The system evolves after deployment. Its behavior is no longer entirely traceable to any single actor. In tort law, we call this the accountability gap, the space between control and consequence. Europe's AI Liability Directive and Product Liability Directive reform, they attempt to bridge that space by shifting the burden of proof. When harm results from a high-risk AI system, the producer must demonstrate that adequate safeguards were existing. The United States, less centralized, it relies on case-by-case negligence and contractual disclaimers. India, drawing on its consumer protection tradition, is exploring hybrid models. Strict liability for developers of critical systems, coupled with fault-based liability for operators. China embeds liability inside administrative oversight, licensing, registration, and state insurance mechanisms for AI-driven sectors. So 4 variations, 1 anxiety: the need to make autonomy answerable. In 2017, the European Parliament's Committee on Legal Affairs, it suggested a radical idea: electronic personhood. The notion was simple. If certain AI systems act autonomously, perhaps they should hold limited legal personality, able to own assets, carry insurance, and be sued. Critics called it absurd, even dangerous, an abdication of human responsibility. Supporters argued that it would bring clarity, a legal shell through which obligations could flow. The debate stalled, but the concept endures. Because every time a system acts beyond its creator's foresight, the ghost of electronic personhood reappears. In legal theory, personhood is not about consciousness. It is about capacity to hold rights and duties. Corporations have it, ships have it, even rivers in India and New Zealand, they have it. The law confers personhood wherever it needs continuity of responsibility. So the question is not moral. Should AI have rights? But procedural. Do we need a legal persona to carry the liabilities of autonomous action? Europe is cautious, preferring enhanced producer liability. The US relies on insurance and indemnification. India's jurists, some inspired by its juridical person doctrine in temple and trust law, they are quietly exploring analogies. China rejects the idea outright. All agency must remain traceable to a human or corporate principle. None are wrong, but all are incomplete to my mind. As autonomy increases, liability will migrate toward risk pools rather than individuals. Just as industrial sector created workers' compensation and vehicle insurance, the AI society will create algorithmic risk funds. In Europe, pilot projects already test collective insurance for autonomous vehicles. In India's fintech sector, regulators consider sandbox insurance, temporary immunity during controlled experimentation. The US leaves this to private markets and China integrates it with state reinsurers. Law is rediscovering an old wisdom. When causation fragments, responsibility must collectivize. This is not surrender. It is adaptation. Liability is the moral infrastructure of innovation. It ensures that progress pays for its own errors. The classical defense against negligence was diligence. I took all reasonable care. In the AI age, diligence means explainability. Can the developer show how the model was trained, tested, monitored? Can the regulator audit its data lineage? Can the affected person contest its output? Europe's AI Act enshrines these duties. The US FTC calls them algorithmic accountability. India's emerging responsible AI guidelines drafted by Niti Aayog, it speaks of traceability and bias testing. China's regulation on recommendation algorithms, they require public disclosure of ranking logic. Transparency is becoming the universal passport of legality. Criminal law introduces another puzzle, intent, mens rea. Can a system intend harm? No. But can it operate with reckless disregard for foreseeable risk? Perhaps yes, through its designers. Jurisdictions will differ. Europe may treat reckless deployment of unsafe AI as a quasi-criminal regulatory offense. The US may use corporate criminal liability. India, where criminal negligence statutes already impose duties on persons in charge, could extend them to AI controllers. And China prefers administrative penalties, not moral blame. So slowly we see that law is detaching culpability from consciousness and attaching it to control and forcibility. That evolution mirrors industrial safety law from a century back. Only now the machines learn back. Some fear that granting any form of legal identity to AI will dehumanize law. Yet personhood in jurisprudence is always instrumental. When the Roman jurists created the concept of the corporation, they did not believe that buildings could think. They believed accountability required a vessel. So too with algorithms. We may eventually create limited purpose electronic entities, registered, insured, auditable, through which autonomous systems operate. The goal is not to humanize machines, but to institutionalize responsibility. In that world, India's trust law, Europe's corporate law, and America's limited liability doctrine, they all may converge. Entities with legal capacity, moral neutrality, and regulated accountability. So whether we call it electronic personhood or algorithmic trusteeship, the principle is the same. No autonomy without accountability. We can already see outlines of a global doctrine forming. Human-in-the-loop principle, mandating human oversight for critical decisions. Explainability and auditability, the procedural right to reason. Strict liability for deployment, those who unleash autonomy, they bear its possible risks. Insurance of fund mechanisms to socialize residual harm. Regulatory sandboxes, spaces for safe experimentation. Europe codifies these in regulation. The US and India test these through policy. And China, it implements them through licensing. The vocabulary may differ, but the grammar of accountability is converging. Personhood is a legal fiction, but a necessary one. It allows societies to translate power into responsibility. Artificial intelligence is the newest holder of power, and therefore it must find its place within that fiction. The challenge is not whether machines will become persons. The challenge is whether we, the humans who design them, will remain morally present in their actions. When future historians read our statutes, they will not ask whether we feared AI. They'll ask whether we built a jurisprudence worthy of intelligence. To answer yes, we must make sure that every autonomous act, no matter how synthetic its origin, it leaves behind a human trace of duty. That is what it means to keep autonomy within the rule of law.